Is the chief joining us this morning?
I don't believe so.
Okay.
Madam Secretary, I'll be right back.
Okay. Hello, Mr. Yan. Good morning. I think we are.
Good morning, everybody.
Good morning.
Can't hear you.
Good morning, Commissioner Feinstein. Mark LaCroix here.
Good morning. I think we're all here. Let me know when you want to call the meeting to order and I'll announce the initial startup.
I don't have any sound.
You can't hear me? Okay, I'm going to have to call. Hi, it's Maureen down at the commission in my office. And I am trying to get my mic to work.
I can hear you now, Maureen, if you can hear me.
Oh, you can hear me?
Yes.
Okay, all right, it's working.
Can I hear the other commissioners?
All right, thanks. Bye-bye.
Good morning.
Good, thank you. Good morning, Commissioner Covington. Vice President Nacasio?
Good morning, Madam President. Good morning,
All
all.
right. And Mr. Yan, Mr. Russi, and our member, can you all hear everybody? Yes.
Yes.
Yes, ma'am.
Okay. I don't know what that issue was, so apologies. All right. Shall we get started?
Okay. This is the Fire Commission special meeting on April 6, 2022. The time is 10:05. This meeting is being held by WebEx pursuant to Government Code Section 54953E and the mayoral proclamations declaring the existence of a local emergency. To join the meeting, use the link address for attendee, which is on the posted agenda on the Commission website. To participate during public comment, please call 1-415-655-0001 and use access code 2482-970-9589. Members of the public will have opportunities to participate during public comment. The public is asked to wait for the particular agenda item before making a comment on that item. Comments will be addressed in the order they are received. When the moderator announces that the commission is taking public comment, members of the public can raise their hand by pressing *3 and you will be queued. Callers will hear silence when waiting for your turn to speak. Operator will unmute you. When prompted, callers will have 2 minutes to provide comment. Please ensure you are in a quiet location, speak clearly, and turn off any TVs or radios around you. And I believe if you're logged in as an attendee, there's an actual button to raise your hand. Item 1, roll call. President Catherine Feinstein.
Present.
Vice President Stephen Nacasio.
Present.
Commissioner Francie Covington.
Present.
And Commissioner Army Morgan has been excused. Item 2, public comment on item 3. Public comment on all matters pertaining to item 3A, including public comment on whether to hold item 3A in closed session. Should we call for public comment?
Yes, please.
Okay, I only see 2 hands raised.
All right. Let's proceed with those two.
Would you like to make public comment?
It should be 3 minutes.
Yes, I would.
I'm sorry, it's 3 minutes?
Yes.
No, it's 2 minutes.
Hello.
2 minutes? Okay, your time starts now.
Hello, Commissioners. This is Ryan Crow from yesterday's hearing. I just wanted to make some points to the appeal that was not ruled on yesterday. The Skelly notice from the chief on October 15th cites Charter 341 and 344. 341 states the notice to appeal would be issued to the member in writing by mail.
Sir, I'm going to interrupt you. This is public comment on item 3 on this agenda.
Okay, well, I'll call back when this comes up.
Thank you. Caller, would you like to make public comment on item 3A?
Yes, please. Thank you. Christopher Salas, retired at San Francisco Fire Department. Greetings, brothers and sisters. Welcome once again to the Kangaroo Court of the San Francisco Fire Commission, where verdicts are predetermined, facts are ignored, and definitions of words are targeted or ignored to prevent the truth from being acknowledged. where due process is trampled on like we live in the Soviet Union. Vaccines do not prevent COVID, authorized or not. Vaccines do not prevent hospitalization or severe illness.
Sir, I'm stopping your time for a moment. This is actually public comment on item 3A, which is an employee dismissal case, a motion to dismiss.
Back to due process then. Let's read the definition of due process. An established course for judicial proceedings or other government activities designed to safeguard the legal rights of the individual. A legal concept where a person is ensured all legal rights when deprived of life, liberty, and the pursuit of happiness for a given reason. The limits of laws and legal proceedings so as to ensure a person's fairness, justice, and liberty. No kangaroo court on God's green earth can claim due process is adhered to when predetermined verdicts and charges in lieu of charges that are doomed to fail replace the charges that were in place to begin with. Those are the hallmarks of tyranny, perpetrated by people with a skewed moral compass, if they have one at all. God bless you, Mark, on your righteous fight for due process today. Prayers to the perpetrators of injustice, who you know who you are. Thank you.
Thank you. And that is all the public comment that is showing on my computer.
Too much coffee.
All right, then public comment will be closed if there are no further people that wish to comment, and we will proceed with the motion that was filed by, and I want to make sure I pronounce your name correctly, sir. Is it LaCroix?
Oh, LaCroix is how I usually pronounce it.
LaCroix. Okay, forgive me. I just wasn't sure. So
Yeah.
thank you.
In a lot of parts of the world, they do say LaCroix. So thank you for your question, President Feinstein.
Well, I wanted to at least get that right.
I'll respond to either, but I usually do LaCroix.
Okay, you got it. Okay, this is, I guess the first thing that we have to decide here is what, and this is your call with a response by the city. Do you wish this to proceed, since it's more of a procedural matter than a substantive one? Do you wish to proceed in open session
Yes.
or closed session? It's your call. I need to get the city's response, but tell me how you'd like to proceed.
Open session, please.
All right. And does the city have any objection?
No, ma'am. No objection from the department. Thank you.
All right, thank you. So we will proceed in open session. There is the possibility that the commission will subsequently decide to discuss this matter in deliberations in closed session. Again, it's a little odd because it's a motion, not we're not getting to the merits of Mr. LaCroix's overall situation. So what we're really doing is, I would call it a demur hearing if we were in court. And yeah, I have received and considered, and I believe my fellow commissioners have too, the request for, or the motion to dismiss from Mr. LaCroix filed on January 4th. I've received the fire department's response dated January 27th. I've received Mr. LaCroix's opposition to that February 1, and the amended pleading of the fire department that was filed on March 10th. And in terms of how we proceed with this, this is Mr. LaCroix's motion. So I'm going to let him speak first. And again, we're dealing with the dismissal motion only today. And then we'll turn to the department. It's a little bit backwards from how we do the regular hearings, but it is your motion, sir. So if there's anything you would like to say in argument for your motion to dismiss, now would be the time.
Okay, I was preparing for this and I realized since the department is is attempting to amend the charges, if the charges are amended, does that undermine this motion to dismiss in basically that it's moot? Because those charges may not be dismissed if they're amended.
The in terms of ending that, it does not. Does not render your motion to dismiss moot.
Okay, so where is that going to play into this hearing? The amended charges.
Well, that's what we need to decide as a commission regarding the city's or the department's desire to amend the charges.
Okay, all right.
So I mean I understand what you're asking, but I think we should proceed with your motion.
Okay, we can do that. I would like to I'm basically going to read from my motion and my reply
Okay.
paper.
And I'm going to ask one favor, which is that don't read too fast, please. People have a tendency to do that, and things can get garbled up. So if you would just read slowly, that would be appreciated.
Understood.
Thank you.
Okay. Good morning, commissioners. Thank you for hearing my motion. I'm going to read from my motion to dismiss and reply paper. I'm trying not to get too many details in there. So here we go. I wish to make a motion to dismiss the recommendation for non-disciplinary separation for failure to comply with the vaccination requirement of the city and county of San Francisco order of the health officer. And I'm simply going to call it the health order from now on. I am fully compliant with the health order. The health order only compels vaccination for those personnel that enter high-risk settings. I, however, do not enter high-risk settings in the performance of my daily duties and have not once entered a high-risk setting in the performance of my job as fireboat engineer since being hired in 2015. The health order is the sole policy cited in the verified complaint by the chief. Given that, the department's discovery obligations were to provide the entire investigative file relating to the investigation of the case, any evidence the chief relied on, and all evidence the department intends to introduce. I am motioning for a dismissal on the grounds of insufficient evidence. Chief Nicholson's entire basis for the recommended non-disciplinary separation, as I stated, is for, quote, failure to comply with the vaccination requirement of the city and county of San Francisco order of the health officer. The health order requires, this is still quote, the health order requires that all city employees be fully vaccinated no later than November 1st, 2021, unless they have been approved for an exemption for a medical condition or sincerely held religious belief, unquote. The chief's statement that the health order requires all city employees to be fully vaccinated no later than November 1st, 2021 is totally false and nowhere to be found in the health order. A cursory examination of the health order will prove this to be true. In fact, the health order specifically, I'm going to leave that sentence out. The department has had ample time and opportunity to address my assertion that the vaccination requirement of the health order does not apply to me, as I do not enter high-risk settings. The department has not produced any evidence to support their allegation. To support my motion, I have submitted for evidence an employee appeal of high-risk setting determination form, approved within the department and submitted by email to Jesus Bouchon and Lucy Chu of the Human Resources, San Francisco Fire Department Human Resources, on August 31st, 2021. I also emailed this form to the Chief's Assistant, Teresa Ludwig, on November 4th, 2021, for evidence and discussion during my administrative hearing with the Chief on that day. PDF copies of these emails and my approved risk setting determination form are attached for evidence submittal. With regards to the hearing of my motion prior to the department's case in chief, you know what? I'm going to leave that one out too. The remedy I am seeking is to be immediately reinstated back into my position as fireboat engineer. I'm also asking for payment of salary for my time under suspension, unpaid administrative leave, as well as my earned vacation time to be reinstated to my accrued time prior to November 15th, 2021. Thank you.
Thank you. Does the city have a response?
Yes, ma'am.
Please go ahead.
Sure. So, as evidenced by the department's filing of an amended charge on March 10th, the department recognizes and admits that the initial charges filed against engineer LaCroix were mistaken. They mistakenly cited the health order, which we do not dispute that. And we do not dispute that engineer LaCroix does not fall within the definition of a high-risk employee. Engineer LaCroix, the department is seeking to separate engineer LaCroix not based on his failure to comply with the health order, but his failure to comply with the chief of department's general order, which was issued after the health order, and which requires a larger group of department employees to receive the vaccine. In this case, in the briefing that we have submitted to the commission, we have indicated that neither the firefighters' Bill of Rights nor the due process requirements of the state and federal constitutions, nor any state law would be violated if we are permitted to proceed under the amended charges. They are substantively identical in that they allege that the engineer failed to receive a vaccine contrary to the direct order of the department. The general order was in fact cited on the Skelly document, so there's no due process violation. The firefighter Bill of Rights does not kick in until after the engineer, until the commission, until the point at which the commission chooses, if it so chooses, to separate the engineer. So the firefighter Bill of Rights is not implicated here. Engineer LaCroix has not to date indicated any prejudice that has resulted from the originally incorrect charges that were filed. He hasn't claimed that he needs additional time for discovery. He hasn't claimed that there are any issues that he'd like to look into that he has not had the opportunity to do. So therefore, this is an inadvertent mistake. It has been corrected. There has been no prejudice. There has been no violation of due process, constitutional rights, civil rights, or state and federal law. Therefore, the department respectfully requests that the motion be denied.
All right. I know I have some questions. Let me first. Oh, I'm sorry. Yes, Mr. LaCroix.
I have in fact asked or brought issue that I need discovery all over again to respond for the new charges. I had a whole reply paper to what Mr. Yan just stated. And also, I believe he's misstating the law in the Firefighter Bill of Rights of not having any protections prior to the separation hearing. The Firefighter Bill of Rights specifically says it has protections, it provides protections until I am offered an administrative appeal.
All right. Let me defer to my fellow commissioners. And as I said, I have some questions. Do my fellow commissioners have any questions of either Mr. Yan or Mr. LaCroix?
Before we do this, can I say one other thing?
Sure.
Okay. I thought we were going to address the motion to dismiss. I realize it's convoluted in this matter, but we immediately after my statement went into addressing the amended charges.
Don't worry about that. We are only addressing the motion to dismiss here.
Okay, roger that.
All right. All right, I saw Vice President Nicasio, your hand go up, I believe. Am I right, sir?
Yes, thank you very much, Madam President. A question first for the city attorney, Mr. Yang. As a point of clarification in your statement, and I'm going to paraphrase because I'm not sure, I don't want to make any mistakes, in the sense that the charges that the city are bringing to the member that was dated, I think you referred to March the 10th, was amended in the sense that the member didn't fall into the category of high risk, but you cited the violation as the general order. Is that what, I just need a sense of clarity. Is that what you said, Mr. Yang?
Yes, sir. The general order issued by the department chief requires all employees, including engineer LaCroix, to be vaccinated. That should have been cited as the original basis for his separation. The department simply made a mistake, and the March 10th filing was intended to correct that.
In terms of this question, the city health order and the general order are two separate orders.
Yes, sir.
In terms of this amended charge on March the 10th, there was some reference that it's a new charge. Do you want to respond to that?
It's not a new charge for purposes of due process. And that's because in the original due process requires that the charges be outlined to the member in the original Skelly document. The Skelly document in this case is the November 4th, 2021 letter sent by Chief Nicholson to Engineer LaCroix, which sets forward the bases for his separation. In that letter, which I attached to the department's filing last week, that letter clearly cites both the health order and the general order. Now, of course, the health order should not have been cited because he is not, as Engineer LaCroix correctly states, the health order does not apply to him, at least not in the way that it is applied to the other engineers or the other firefighters. The general order, however, does apply to him, and it was cited in the charging document. So he has been apprised of his of the basis for his separation, and so therefore there's no due process violation there. To the extent we will admit and concede that the original complaints filed with the commission did not include the general order, and that's why we filed an amended complaint on March 10th to correct that procedural violation. If yes, so therefore, there was a procedural mistake. We cited the wrong basis for separation, but the actual conduct that is alleged, which is the failure to obtain a vaccination, remains the same. And therefore, we don't believe that the department does not believe that a motion to dismiss is warranted in this case.
All right, Mr. City Attorney, Madam President, I have a question for the member.
All right, please proceed. Mr. LaCroix, if you will answer Vice President Nicasio's questions, please.
Indeed.
Firefighter LaCroix, Firebolt Engineer LaCroix. You stated in your verbal opening statement that you felt a motion for dismissal in terms of the category of being not a high-risk member that enters a high-risk scene, which the department now has affirmed. Now understanding what the discussion has been, and the department has moved that charge to a general order, are you comprehending the violation of the general order?
Yes, I do comprehend the violation. However, the November 4th letter that's now being called a Skelly letter does state that the general order and the health order were what's being looked at as charges against me. And then I was afforded an opportunity to bring evidence and an argument to the chief on November 4th of 2021, which I did, and I argued against both policies. The chief then made a verified complaint signed under the penalty of perjury that she was moving forward with only the health order. And that is the entirety of the verified complaint that she moved forward with. So that was my entire defense. It's been 4.5 months since I've received a paycheck. It's been over 5 months since my hearing with her. And I've spent nearly $3,000 in legal consultation to prepare for a defense against the health order. Now, the amended charge undermines that entire defense. The general order and the vaccination order contained within the general order all have different issuing authorities, and as such, and different content. So as such, by the hearing procedures of the Fire Commission, what I'm going to request is to be made whole up until the point that you rule on this amended charge. If that's today, however, there is further argument against them, the ability to amend a charge that I'll reserve here. But to answer your question, what I'm going to ask for is 10 days discovery, which is in your hearing procedures. I want 3 days to be able to process that discovery and make an argument, and then the hearing procedures call for 14 days prior to the separation hearing that I submit evidence and a witness list. And so I believe that's what we're talking about, due process, is I get these time periods to prepare for the new charges.
All right, thank you
Does that
very much
answer your-
for that.
Does that answer your question, Commissioner Nakajo?
Well, my question was basically, did you comprehend the charges of the general order? And I think you affirmed that. My other question for clarity is that your narrative justification was because of you didn't feel the categorical being a member that entered high risk areas. But on your packet, there's a documentation of an exemption request for religious. So my question of clarity is, what was your justification based on this motion to dismiss? Is it based on the concept that you're not a member that enters a high risk section, or is that it?
The charge against me was the health order, and the substance of my motion to dismiss is lack of evidence that the health order applies to me. Does that
All right.
answer
Thank
your
you very
question?
much. Yes, thank you very much. Thank you, Madam President.
All right. Commissioner Covington, I don't know if you have any questions. I have a couple, but am happy to defer to you if you would like to proceed, or perhaps not. You can
Okay,
come
thank
after
you.
me. Up to you.
Thank you, Madam President. I do have a couple of questions, and then after you have made your comments, I probably will have some more. So I wanted to know, Engineer LaCroix, are you aware that the city and county asked all employees to be vaccinated? Even those who don't go into high risk areas?
Yes, I'm aware. Well, I'm gonna answer that this way. The city charges with complying with the policies, and I'm aware of the contents of the policies.
All right. So you have not taken the vaccine. Do you intend to ever take the vaccine?
I don't believe that issue is pertinent here today. I would like to decline to answer that question.
Okay, that's
Respectfully.
fine. No, that's fine. I know that as an engineer, you are out on the boat, but from time to time, there's a jumper on the bridge, or there are other situations that bring you in contact with the general public, including those people who come from different parts of the world. What precautions would you take in those cases to keep people safe?
Okay, good question. As the engineer on the fireboat, when we're doing recovery operations or any rescue operations, I do not have patient contact. I man the engine room, and I've got some controls in the pilot house of the boat. Once again, I can socially distance. If we do have a recovery, I run the crane, which is going to be at least 20 feet away from any any operation going on. It could be because it's on the upper deck and everything happens on the lower deck of the fireboat. There are masking policies which I comply with, and that's what got us through this pandemic. Largely, they cited the PPE, and I'm fully compliant with all the PPE requirements. Does that do you want me to expand further, or does that answer your question?
No, that answers my question somewhat. I know that the engineer is, at the top of the boat, and then I think I've met you on occasion.
Yes, we were on a fireboat ride together. I remember meeting you.
Okay. Yes, thank you. So when I saw your face, I thought, oh, I know him.
Yes, we had a
Uh,
short, lovely conversation at the time.
Yes. So, we do have in the department a person who is in charge of, oh my goodness, it escapes me just at this moment. But in the event of some catastrophic attack on the city, and people are running everywhere, and you are, piloting as best you can to handle anybody who might be in the water. In a dire circumstance, even the pilot room is going to be full with people.
Oh, I'm sorry. I'm not the pilot of the boat. I'm the engineer of the boat. The engine room is my domain.
Oh, so you're down. Okay. All right. Now I see. Now I see the levels. Yes.
Okay, there are controls, like if you take the Pier 45 fire that happened, I was on that day. There are controls in the pilot house that I direct the water on the fire. So that is one situation, but that's usually removed from rescue operations.
But I was asking the question in terms of needing places for people to be put.
Okay.
Yes, so that you would be coming in contact with other people.
Yeah, the engine room is my domain, so they're not going to put people down there unless they had hearing protection for them. There's not much room. It's machinery spaces. They're dangerous. There's no personnel allowed in the engine room except for basically me and the firefighters.
And which boat are you on?
All three boats.
Okay, so the St. Francis, okay,
Venus and the Guardian.
All three. Okay. I need to formulate my questions more succinctly, Madam President. So I will circle back if I need to after you've asked your questions.
All right, that's just fine. And forgive me, and I just want to confirm this more for our records than anything. Am I correct that you are an F-110? Is that no?
It's an H-110. H-110.
Okay, I'm scared.
There's several errors on the paperwork. First, I was an H3, and then I had notified them of that problem with the Skelly notice, and they amended it to an H10, which is an incident support specialist.
Which you are not.
which is a firefighter. And that may be where some of the confusion was, because both the H3 and the H10s do go into high-risk settings.
Understood.
So these were clerical errors, probably.
Mm.
That could be. Let me ask you a question and forgive my ignorance. Are you a firefighter?
So that's a good question. I reached out to 798 some months ago to ask if the firefighter Bill of Rights pertained to me, if I was afforded protections under those. They assured me that yes, indeed they do. The firefighter Bill of Rights is incorporated into the Constitution and bylaws of Local 97 or Local 798. Also, I do apply water to fire. I have not gone through the specific training for the firefighters. I was military, I was Navy, I had shipboard and aircraft firefighting courses that I had to complete in the Navy. And I've been through, I believe, 3 firefighting courses in the maritime industry. One of the biggest was I attended California Maritime Academy, where I got a bachelor's degree in marine engineering. And there was I believe it was a week-long firefighting course that was part of that curriculum, and constant drills on the 6 months of shipboard time in firefighting duties.
But let me just rephrase it.
Okay.
Do you ever get off the boat to fight a fire?
Negative.
That's what I suspected, but I wanted to make sure I understood your job duties.
Okay.
So you're the one making the operations of the boat run smoothly. A ship, boat, I always mess that up, but you know what I'm talking about. And that there's water getting pumped and the water is getting directed where it needs to go and that sort of thing. Am I correct?
You are correct. We can pump water through our fire monitors, and
Right.
like on the new boat, they go up to 430 feet. So I get the luxury of being in the firehouse and reaching out very far. We also can pump over land with through hoses. So we have 3,000 feet of 3-inch fire hose, and we have 1,100 feet of the 5-inch fire hose.
Yeah.
And I make those connections on the fireboat with the help of the firefighters, and then can pump ashore. But I'm aboard the vessel.
I see. Okay. All right. I'm going to turn to Mr. Yan for a moment here. Mr. Yan, you're with me?
Yes.
All right. I'm looking back here at the San Francisco Fire Department's opposition to motion to dismiss, dated January 27th, 22. It was authored by Ms. Stoughton, and in it, towards the very end, she says, the procedural rules, section 9B, specify that, quote, any motion to dismiss on the ground of alleged insufficiency of evidence may not be heard or decided until after the close of the department's case in chief, unquote. Well, my comment and question about that is we're not talking about whether there is sufficient evidence or not sufficient evidence, because we haven't heard any evidence. And I mean, that seems to me to be a bit misleading in that, yeah, as I said, I'm viewing this a bit like a demur. There's a defect in the pleadings, and I think that you have conceded that there was a defect in the pleadings. And I was a bit struck by that feels to me to be an inappropriate assertion. It's a very short pleading, and that's what it says. You can't do this because you haven't let us put in our case in chief. Well, in fact, if you are charging someone with the wrong thing, it can be dismissed. We don't have to wait till after the department's case in chief. Am I incorrect somehow? Do you disagree with me?
No, Madam President, I don't disagree with your statement. I would like to respond to
Please.
your comment with regard to my colleague, Ms. Stoughton's briefing. I believe that her comment was a response to the initial moving papers filed by Engineer LaCroix. So you are correct. I also view this as comparable to a demurrer or a motion to dismiss in federal court. However, in his initial briefing, firefighter LaCroix, and I'm quoting from his papers, he wrote, quote, "I do not enter high-risk settings in the performance of my daily duties and have not once entered a high-risk setting in the performance of my job as fireboat engineer since being hired in 2015. That's a statement of fact that requires evidence. You've heard the engineer state multiple times that there's no evidence that he enters high-risk settings. So I do not believe Ms. Stoughton's briefing or the department's briefing was intended to be misleading. It was a response to the statement that that the department has not entered any evidence. Of course, the department hasn't entered any evidence because the time for entering evidence is at the hearing. And so that was a comment. It was not intended to be misleading in any way. And I apologize on behalf of the department if you felt misled.
Right.
With regard to,
I'm sorry.
oh,
Excuse me. No, I'm sorry. I didn't mean to interrupt.
okay, that's fine. Now, with regard to your comment, you are correct that the commission has the right, if it chooses, to dismiss this. The only consideration I would put before you is is the consideration of prejudice. Now, in this case, if in this case there's been no allegation of any prejudice that has resulted from the department's admittedly mistaken citation of the wrong basis for Engineer LaCroix's separation. The department fully admits that it screwed this one up. The paperwork was wrong. It cited the wrong, as Engineer LaCroix correctly pointed out, it misstated his rank. It cited the wrong order. That was a screw up on the department's part. That being said, you have also heard the engineer concede that he knew the bases for his termination, that he knew that the general order was included in the Skelly documents, that he had an opportunity to discuss the general order during his administrative hearing. And now it's been almost a month since the department has updated its charges, conceding the mistake and has corrected the procedural issues. So at this point, what we have is an admitted error in the drafting and the briefing, but not an error on the substance. And the substance being that it was, the department made a determination that it needed in order to carry out its mission to the best of in order to carry out its public safety mission, it needed engineers to be vaccinated, such as fireboat engineer LaCroix. And therefore, and because he refused to comply with that order, the department decided that it had to let him go. The department intends to defend that decision and to present evidence as to why that decision needed to be made and why it was reasonable and why the commission should uphold that decision. But this is not the time for that evidentiary showing. We intend to present evidence and witnesses to make that showing at the hearing. The only question now is whether the entire hearing should be thrown out and whether the separation should be canceled because of what amounts to a clerical error. And I don't think there's any basis for that.
Well, let me, Mr. Yan, ask you this. The amended pleading that was filed on March 10th of 2022 references both the city's vaccination policy and the general order.
Yes, ma'am, it does.
And my question is, aren't you stepping into this again? I mean, What are you alleging in this amended pleading that engineer LaCroix failed to comply with?
The department is alleging that
That
engineer,
applies to him.
right, the department is alleging that engineer LaCroix failed to comply with the general order issued by the chief of the department. The chief of the department ordered all members, including him, to be vaccinated, and he defied a direct order from the chief, and that is why the department has decided to request a separation. And that was set forth in the amended papers, and I don't think we've heard any testimony that suggests that engineer LaCroix was confused or mistaken about the reasons why the department was seeking his termination.
Well, I'll tell you, the pleadings are confusing to me, and I've read a lot more pleadings than I'm not speaking for engineer LaCroix. Maybe he's read more than me, but I'm guessing I've read more than him. And it makes it very confusing. Let me ask you, what would prevent the city from starting over again? Repleting this, if we were to dismiss these charges, what would prevent you?
Nothing. I mean, I don't see, there's no reason why the city couldn't start over. The only question is whether that is necessary or a good use of or a good use of time. I understand that it was confusing, but at the end of the day, there have been two pleadings. There was the initial mistaken pleading and the subsequent corrected pleading. If engineer LaCroix feels confused and feels like he needs a little bit more time to gather his evidence and prepare his case, the department doesn't have a problem with that. But I don't see any need to start over from scratch. Doing so would simply, would consume time and resources for what amounts to a clerical error. And if we were in civil court, clerical errors can be easily remedied, and the case can continue. So there's no reason, I think, to require a return to the starting line, so to speak.
All right. Well, I'm gonna maybe say something I shouldn't say, but you talk about time and you talk about resources. And what I'm going to say on behalf of my fellow commissioners, regardless of what certain members may think or not think, we are the volunteers here. We have put in hundreds of hours into these matters. And we rely upon pleadings to be accurate, to be truthful. I'm less I'm less concerned, frankly, about the city attorney's hours and effort than I am about doing things fairly and justly. So that one doesn't fly really well with me. And I, that's the only comment I have to make. And I'll turn it back to Commissioner Covington.
Okay, thank you, Madam President. Engineer LaCroix, how many engineers are there in the set?
I'm sorry.
Pardon?
I'm sorry. I thought you were finished and then you started again. I'll wait till you finish your question.
Okay, it's a simple question. How many members of the department are engineers?
We have 3 full-time engineers and we have 2 part-time engineers as needed.
Okay, so that is a small and select group of people.
I believe that's an accurate statement.
Okay. And I'm having some difficulty with my feed. People are fading in and out. Is that happening to anyone else?
No.
No, okay, all right then. Just so that I make sure that that I'm on track. And if you don't know, you can just tell me, but I think that you are the first, I know you are the first engineer during this process that has come before us. Have any other engineers been called before the commission? If you're not aware of it, then you can just say you don't know, it's fine.
I'm unaware. I don't know if you refer to under these policies.
Yes, under these policies.
I believe the answer is no then.
Okay. All right, thank you. I think that even though the time has gone on, and even though the department's attorney feels that no harm has been done, clerical errors in the law impact people's lives. It's just as simple as that. That's all I have to say. Thank you.
Thank you. Commissioner Nakajo? Mr.
Madam
Vice President?
Thank you, Madam President. I would like to ask the member a question again.
Please.
I'm going to paraphrase and give you some foundation for my question. And I don't want to be repetitious within it, but I just need to hear it one more time with the dialogue that we've just had. And take this advantage of the commissioners asking some questions, but also giving you, Fireboat Engineer LaCroix, an opportunity to respond. It was established again that, and I'm not trying to be repetitious, that your justification and cause for motion to dismiss was that you weren't a high-risk setting. And we've already went through dialogue and discussion in terms of that particular charge. And I did make mention, because I know that you're going to be submitting, or you have in your verbalization, submitted your religious exemption, which was denied. So again, my question is that my question was a verification of your understanding and comprehension of the general order that the chief gave. And I took away from your last answer that you comprehended that. Is that correct?
I'm fully aware, and I believe I understand the orders.
Which
I'm sorry, go ahead.
I'm not trying to interrupt you respectfully, but which was to fully be vaccinated and come into compliance.
That isn't exactly what the order states. It says to comply with the policy. The
Okay.
policy has some avenues for exemptions.
I understand that. But I'm trying to get in there that the concept was to be fully vaccinated, COVID-19. Now, having said that,
Now,
that's my
hold on one second there. If we're going to discuss the contents of the new charges, which I believe might be a little outside of the scope of this hearing, I would request a short break so I can pull up the policy.
I'm not referring to the semantics of new charges, or Mr. Yang talked about consistent change charges with an error clerical. I'm just trying to get to the question. And it was asked before of you, and you answered it in the sense that you declined to answer it. But my question again is understanding the general order. And just as a point of information, there was dialogue and information provided that all members of the city and county of San Francisco who are employed by the city and council need to be vaccinated as well. And just as a point of information for yourself, we commissioners also have had a mandate to be fully vaccinated. My question to you, and you answered that you did wish not to answer it, is that would you ever fully consider being fully vaccinated?
That's going to go into the content of my sincerely held beliefs, which is protected information. So if we wanted to meet privately and have a discussion about that, we could do that. If you wanted to have a phone call on a break and do that, we could do that. I'm
No,
not going
that's
to do it
not,
in a public forum.
granted and respected to your reply. I just asked the answer. I asked the question. Oh, you rendered your answer. You answered it before. I don't want to be a repetition. So respectfully, I'll conclude at this point. Thank you, Madam President.
Thank you, Mr. Vice President. Are there any further questions for Mr. Yan or the member? Okay, I'm not seeing Commissioner Covington's pen or Vice President Nakasio's hand. So I'm going to conclude that there are not. I don't know if there's anything either the department or engineer LaCroix wish to add at this point. I don't think you need to add anything, but it's you want, if you would like to say a few words in closing, you're welcome to do so.
Okay, if we're already at closing, let me make another point here. We talked about pleadings and amending pleadings. So I did submit a brief to the commission a few days ago. I believe it was Friday. And in there, I specifically addressed amended pleadings. And there's some pretty good content in there. I could read from it if you want. But I'd like to first ask if the commissioners have my brief for evidence.
I believe we do.
Oh,
Yes.
okay, and we have talked about time, and I don't wish to waste the commissioner's time any more than anybody else does. So in there, I pointed out that the fire commission's hearing procedures don't address specifically any amended pleadings. So there is some California statute that would apply, and that's the Rule of Court 3.1324. And in there, it says that pleadings are amended by motion, and so they basically have to come to you, Ms. Feinstein, and ask to amend the pleadings, which the department didn't do. They might not have been aware of this since it came from the chief's office. I know it's she's not a lawyer.
May I? I don't mean to interrupt, but I am interrupting. So let me just ask this question because I'm going to ask it of Mr. Yan too. Do you have any argument on whether you believe the commission should accept the amended charges? Do you have a position on that?
I believe it's within your ability to do that. I believe this rule of court citation that I cite here, I believe it's got some very good points. I'm going to read a few excerpts from it. So in this, in the motion that it says in California law to amend a pleading, under 3.1324, a little ways into it, under B, supporting declaration. A separate declaration must accompany the motion and must specify, 1, the effect of the amendment, 2, why the amendment is necessary and proper, 3, when the facts giving rise to the amended allegations were discovered, and 4, the reason why the request for the amendment was not made earlier. And so those are some answers I would like going forward. And here's one little problem though, is the time frame or the deadlines for motions in my case was March 3rd was the last day for motions in my case, and the amended pleadings came March 10th.
Noted. Well noted. All right, Mr. Yan, do you have a response to my concern?
Yes, yes, Madam President, but if you don't mind, if you could just state your concern one additional time. I believe
Well,
there were some.
I'm concerned about whether or not, I mean, I think Engineer LaCroix just made a point, which is that the amended pleadings came after the dates that we set for everything. And as you know, I'm not sure if you participated or Ms. Stoughton participated, but we had a case management conference and we agreed on dates for things. And after discovery closes, and somebody files an amended pleading, that's not, as I would say, kosher. And nobody came forward other than the member to say, hey, wait a minute, I filed everything, and I've got to say, he's done a very good job in compiling his exhibits and arguments, and it's a bit not fair to after the deadline. And I appreciate people that follow the deadlines, let me say, Engineer LaCroix, I very much appreciate it, but then to come forward with an amended pleading, and it was just an amended pleading. There was no, let's, talk about this again. Let's relook at discovery. Let's basically start over.
So, Madam President, let me kind of address that concern as well as some of the other concerns raised by the commissioners, including the statement from Commissioner Covington that clerical errors do in fact impact people's lives. No question, no dispute about that. And I don't want my comments to be interpreted as being dismissive of clerical errors or dismissive of this commission's concerns. I've appeared before this commission several times, and and I take its concerns very seriously and very personally. In this case, I agree with you, Madam President, that the situation that the department currently finds itself in is not ideal. To put simply, we have egg in our face. This was mishandled at the outset, and there's no way to sugarcoat that. The commission's rules, unlike Rule of Court 3.1324, do not require a motion in order to amend a pleading, and so we didn't file one. If the question is whether or not fireboat engineer LaCroix deserves additional time in order to prepare for the hearing, the department doesn't have a problem with that. I would only put forward the fact that there's been no showing as to how discovery might have been different, or what documentation might have been necessary, or how the last couple months might have proceeded differently had the department prepared its pleadings properly and cited the right order. And that's because at the end of the day, the conduct being alleged remains the same. At the end of the day, the engineer did not receive a vaccination despite knowing that there was a department order requiring him to do so. And so, whether the department is charging under order A versus order B, that of course, I'm not trying to indicate that that's not important. Of course it's important. Of course rules are important. Of course due process is important. But at the end of the day, there's been no actual prejudice because the member knew of his duties, was apprised of his duties, received all of the hearings he was required to receive under the federal and state constitutions, and has not indicated what discovery he might need differently. Now, with that said, Rule 3.1324 wouldn't compel a different result. The effect of the amendment is minimal in that it changes, in that it just changes the target of the evidence, in that the order being cited is different. The amendment is necessary and proper in order to conform to the actual Skelly notice, the reasons why the engineer is being separated. The facts giving rise to when the facts giving rise to the amended allegations were discovered, there was no factual difference. The facts remain the same, which is that the engineer did not receive the vaccination in time. Why the request for amendment was not made earlier, it was made as soon as we realized the mistake.
All right,
And
I'm sorry, excuse me.
so all I would say is that I understand the council's concerns. The engineer has indicated that he might need 14 to 21 additional days in order to prepare a new discovery or to request new information. We have no problem with that. The only, the question then is, is there a need to go further and to dismiss these charges and require the department to restart the Skelly process from scratch? And I've seen no indication why that is necessary.
Okay, let me
So-
let me ask you this question. He did, Engineer LaCroix did file for a religious exemption. Do you know if that was evaluated under the health order or under the general order?
I believe it was evaluated under both. That is a showing that we can, we will answer that question when we have the witnesses with personal knowledge at the hearing.
Would it have made a difference? Does it make a difference which order it's evaluated under?
And that was going to be my second point. No, I don't believe it makes a difference. The religious exemption process is defined by the Constitution and laws that have been passed implementing the Constitution. And so ultimately, the order doesn't change how religious exemptions are evaluated.
All right.
Was Mr. Yan involved in the religious exemption processing? Does he have direct knowledge of this?
Mr. Yan, I'll let you, I think I know the answer to it, but I will let you answer the question.
So once again, I don't have personal knowledge, which is why I'm not testifying as a witness at the hearing. All I can say is how the exemptions are supposed to be analyzed, and the exemptions are supposed to be analyzed the same whether you are whether you are seeking exemption under Order A or under B. All orders are ultimately subordinate to state, federal law, and the Constitution.
All right. Is there anything further from anybody? I'm not,
I do have something.
yes, sir.
If I was to be made whole up until today's ruling, I would be willing to let the original Skelly notice of November 4th stand, and the chief's administrative meeting, basically that's where we'd have to start over, is moving forward from there. I was as soon as charges were filed, then I would be given 10 days for discovery and at least 14 days until my separation hearing. And so that's 24 days. And then I'd also ask for 3 days more between those two periods to process my discovery until I have to do my pretrial submissions. So if we wanted to stand on the original Skelly notice, I'm okay with that. I would ask that I believe amended pleadings do have to go by motion. So if council wanted to submit an amended pleading complying with this state law, we could move forward with that. But I'm also going to ask for remedy up to today when a ruling is made in pay and vacation and health benefits.
All right, we can't address that at this time.
Which part?
We can't address, we can't negotiate at this point. We need to rule on what's before us right now because that's all that the public notice has indicated that we'd be considering. So
Okay.
You're free to discuss it with the city attorney or whomever you like, but it can't be before the commission today.
Okay, I understand. I
Okay,
understand.
thank you.
If
All
we're going to
right.
strike that whole comment, then we can do that.
No, it's fine. I mean, it's a legitimate question. We just have rules that we have to follow. So that's the reason why we can't have that discussion in this forum at this time.
Understood, President.
Okay. All right. Thank you. If there are no further comments, we're gonna move on to determining the motion. Oh, Commissioner Covington, did you? No. Okay. We're gonna move on to a discussion of this matter. The question is whether we discuss it in open session or in closed session. On this one, I am going to make a motion that we have the discussion in closed session.
May I make one comment first, please?
Sure.
I just, in compliance with the Sunshine Ordinance, was the um, notice of the hearing properly? I'm sorry, I'm drawing a little blank
Posted.
on
Yes,
this.
it was, sir. The agenda was posted.
Okay, the agenda, did it cite the reason for closed session? Because I noticed it didn't match the ones on separation hearings. It didn't cite a code or anything.
No, it cited it as a dispositive motion concerning the verified complaint, and that's appropriate.
Okay, great.
Okay. All right. Is there a second to my motion? Vice President Nacasio, thank you.
Commissioner Covington, how do you vote?
I vote for open.
All right.
The
2 to
motion,
1.
so we go into closed session.
All right. And I'm going to ask at this time, if nobody objects, if we can just take a 10-minute break, 5-minute break. I'd appreciate it. Let's say 10 minutes, and we reconvene in closed session at 11:30, if there's no objection.
No objection.
Okay. Very good. Thank you.
I'll be standing by. Thank you.
Thank you, sir.
Of the definitions of honor, integrity, and truth and courage, you could use a good supply of all of them. Yeah. Mr. Yan, if you had an ounce of honor, integrity, or courage in your bones, you would simply be quiet and refile your case. You have admitted your mistake. Now move on like a man and do the right thing. No, I know. Like, ooh, a bunch of D students. He said, right? A bunch of D students want to tell us how to do things. They do. Where are you guys going? Oh shoot. Fun. Ugh. Sasha gonna be big mad. Bianca and swimming? What? Bianca and swimming? Her two favorite things. Be it. Says it looks like rain. It's okay, I gotta do this. Yeah, that's okay.
Hi, just letting you on. I'm technically also in a hearing with the Fire Commission on my other screen, hence the big boy clothes. So so I call this Zoom formal. Uh, but yeah, so if I shut off my camera in a second, that means that they're back from their break and I have to like turn over here. But so thank you. Yep, this is home. This is the back of my living room wall. Yeah, yeah. We watched a lot of HGTV during the pandemic. So Oh my God. It's the first, oh, it's the first day that I haven't had bargaining in like 2 weeks. But as I told Richard, I am technically in front of the fire commission on this screen, but they're currently on recess. So if my camera goes off, it's because they've come back. Hence the blazer. We just kind of stopped sleeping for the most part. Smells like something's burning. Oh. You guys can talk, you know. I'm just on my headphones, so.
You'll all probably go mute. You'll have to unmute you. Let's see. Okay, we are back in open session, April 6, 2022. This is Public Employee Dismissal, case number 2021-21, and the time is 12:19. Report on any actions taken in closed session as specified in California Government Code Section 54957.1A5 and San Francisco Administrative Code Section 67.12B4.
Good afternoon, Commissioners. Deputy City Attorney Brad Russi. I will report on behalf of the Commission that in the closed session, the Commission unanimously voted to grant Fireboat Engineer LaCroix's motion to dismiss the November 17th recommendation for non-disciplinary separation, and as well as the March 10th amended recommendation for non-disciplinary separation, without leave to the department to file new charges, without prejudice to the department filing new charges in the future with the Commission.
And I believe that Commissioner Covington, you wish to make a personal statement.
Thank you, Madam President. I, for one, would like to suggest that due to the nature of the confusing documents in this case, that the department consider back pay for Engineer LaCroix.
All right.
Okay, item 2, vote to elect whether to disclose any or all discussions held in closed session as specified in San Francisco Administrative Code, Section 67.12A.
I would move that we do not disclose the closed session discussions.
Do we have a second?
I will second the motion.
And Commissioner Covington, how do you vote?
I agree, yes.
The motion is unanimous. And item 4 is adjournment.
May I have one question before you adjourn? First, I'm pleased with your decision. Thank you very much. I believe the commission actually has the power to award me back pay. The way I heard it was a recommendation to the department for back pay. If you give me a minute, I can pull up your hearing procedures. I believe there's wording in there to awarding back pay.
Mr. Russi?
The Commission has made its decision in this matter, so I think we're concluding this hearing for now.
And I also think that's in accord with the agenda that was posted publicly. So this would not be the time for that. My apologies.
Okay, I will. I'll write an email to Maureen and see how we can move forward with that. Thank you very much.
Thank you. Is there a motion to adjourn?
So moved.
All right, Commissioner Covington moves to adjourn. Vice President Nicasio, would you like to second?
I would second that motion to adjourn.
All right.
And President Feinstein?
My vote is to adjourn.
This meeting is adjourned at 12:23.
Thank you, everybody.
Thank you.